In this video, I will explain how a $100,000 contract can turn into a $2 million lawsuit. And by the end of this video, you will learn the hidden contract clauses that create financial time bombs and the exact mistakes that transform small business deals into catastrophic legal battles. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I've spent 3 decades watching smart business owners make the same costly mistakes with their contracts. And today, I'm pulling back the curtain on how this actually happens. A handshake deal, a quick signature on a contract, $100,000 on the line. Fast forward 18 months, and you're staring at a $2 million lawsuit. This isn't a horror story. This happens every single day in American business. Let me tell you about Marcus. Marcus owned a mid-sized software company in Tampa. He landed a contract with a logistics firm to build a custom inventory management system. The deal was worth $100,000. It seemed straightforward. 6 months of development, clear deliverables, both parties were happy. And Marcus signed the contract his client provided. He skimmed it. The money looked right. The timeline made sense. He didn't hire an attorney to review it. After all, it was just $100,000. Why spend $3,000 on legal fees? Well, that decision cost him everything. 3 months into development, Marcus hit a technical roadblock. The client's existing database infrastructure was outdated. Marcus couldn't integrate the new system without a complete overhaul. He needed 3 extra months and another $50,000 to complete the project properly. So he called the client. They refused. The contract said 6 months. The contract said $100,000. Marcus thought he could negotiate. Well, Marcus was wrong, dead wrong. The contract had something called a time is of the essence clause. That meant deadlines weren't flexible. They were absolute. Marcus kept working. He tried to deliver something, anything. But without the infrastructure upgrade, the system was buggy. It crashed, it lost data, and the client's operation suffered. The warehouse couldn't track shipments. They missed deliveries. Their customers started canceling orders. Then came the letter, a demand letter from the client's attorney. They weren't asking for their $100,000 back. They were claiming consequential damages, lost profits, damaged business relationships, reputational harm. The number? $1.8 million. And Marcus couldn't believe it. How could a $100,000 contract create a nearly $2 million liability? Well, the answer was buried in Section 12 of the contract, a clause that Marcus never read. It said that software developer would be liable for all direct and consequential damages resulting from breach of contract or defective work product. No cap, no limit, just unlimited liability. Now, most software companies limit liability to the contract value. Well, Marcus's didn't. His client's attorney had drafted a one-sided agreement. Marcus had signed it without reading. Now he was facing financial ruin. But it gets worse. The contract also had a provision about attorney's fees. It stated the prevailing party in any litigation would recover all attorney's fees and costs. Well, it turns out the client hired the biggest law firm in town. Their fees alone would exceed $200,000. If Marcus lost, he'd pay those too. Now, if you're watching this and thinking about your own business contracts, hit that like button right now and subscribe to this channel. I break down legal landmines like this every single week so you can protect your business before disaster strikes. All right, here's what most business owners don't understand. Contract damages in America follow something called the expectancy principle. When you breach a contract, you don't just owe back the contract price. You owe the other party everything they expected to gain from the deal. In Marcus's case, his client could prove they expected to make $500,000 in additional profit from the improved inventory system. They could prove they lost $300,000 in canceled customer orders. They could prove their reputation suffered, costing them future business. Add it all up with attorney's fees, you got it, $2 million. The court would allow this claim because Marcus's contract had no liability cap. Most commercial contracts include a clause that says total liability should not exceed the contract value. Marcus's contract didn't have this. His client's attorney made sure of it. And there's another clause that destroyed Marcus. It was something called a liquidated damages provision. This clause said if the project was late, Marcus would pay $10,000 per week in damages. Well, the project was 12 weeks late. That's $120,000 right there. And that's before we even get into the consequential damages. All right, so let's add this all up. $100,000 contract, $120,000 in liquidated damages for delays, $1.8 million in consequential damages for business losses, $200,000 in attorney's fees. Total exposure, $2.2 million from a $100,000 deal. And this happens because of what I call liability multipliers. These are contract terms that magnify your risk. Unlimited consequential damages, that's a multiplier. Attorney's fee provisions, that's a multiplier. Liquidated damages clauses, that's a multiplier. Indemnification provisions that make you responsible for third-party claims, you got it, that's a multiplier. When you stack these multipliers in a single contract, a small deal becomes catastrophic. And most business owners don't see these clauses. They focus on the money and on the deliverables. They skip the fine print, and that's where the danger lies. Marcus eventually settled. He paid $650,000 to settle his case, but he had to take out a second mortgage on his home. He lost half his savings. His business barely survived, all because he didn't spend $3,000 to have an attorney review the contract before signing it. The lesson here isn't complicated here, guys. Every contract is a liability document. The money you're making is just one piece. The risk you're accepting is everything else. So before you sign anything over $50,000, have an attorney review it. Look for liability caps. Look for consequential damage waivers. Look for reasonable liquidated damage provisions. And look for mutual attorney's fee clauses. These protections cost almost nothing to add on the front end. They save you millions on the back end. Now, this video helped you understand how small contracts create massive lawsuits. Give it a like and subscribe to my channel for more legal insights that protect your business. And share this with another business owner who needs to hear it. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.